Welcome to the Deep Dive. You send us your sources, we do the reading, and basically give you the essential takeaways, your shortcut to getting up to speed.
Yeah, cutting through the noise.
Exactly. So today, we're looking at something pretty significant. We've got reports suggesting the ST-006 of 2015 proceedings. Well, that they might have been invalid.
And what that could mean for a group of former RBC estate constables. It's quite a situation.
It really is. We've got analysis documents, an official findings report, a fair bit to go through. So our mission for you today is to really understand why these reports are arguing the whole thing was flawed. And crucially, what that means for these officers now. Could new legal doors be opening?
Right, specifically around their original redundancy.
Okay, let's get into it. Where does this all start?
Well, it really kicks off back in 2014 with the termination itself. RBC's stated reason for letting go of 42 estate constables was redundancy.
Redundancy.
Okay. Yeah, and these reports really hammer this point home. Redundancy isn't the same as retrenchment under the law here in Trinidad and Tobago. That initial label, redundancy, it's apparently key to everything that follows.
Right, that distinction seems critical. So RBC calls it redundancy, but then the State Police Association, the EPA, steps in.
Exactly. They file this matter, ST-006 of 2015, but they frame it as a retrenchment dispute.
Ah, okay. So right there's a mismatch.
A potential mismatch, yeah. And this is where, it gets really interesting, legally speaking. The reports basically argue the EPA might not have even had the legal right, the standing, to bring that case at all.
How so? What's the basis for that argument?
Well, it seems to center on Section 59 of the Industrial Relations Act, Chapter 88.01. The reports dig into this.
Okay.
And Section 59 lays out what a recognized majority union needs to do to start a trade dispute. Things like providing a list of the workers involved, showing they actually have the majority's authorization to act.
Standard procedural stuff, you'd think.
You would. But the reports claim the EPA fell short. Allegedly, no list of officers provided, no clear proof of majority authorization, and even the affidavit filed, apparently by someone named Clay Hackett, didn't clearly state who exactly the EPA was representing.
So those things weren't done properly.
Then the argument is the EPA's filing could be legally void, maybe even, the reports suggest, potentially fraudulent. That lack of standing is a huge question mark right at the start.
Wow, okay. So if they didn't have the legal right to file, the whole ST-006 thing could just unravel from step one.
That's the implication being drawn.
And it loops back to that initial classification, doesn't it? Redundancy versus retrenchment.
Yeah.
Why is that specific error calling it retrenchment when RBC said redundancy is so important according to these documents?
Because they trigger completely different legal pathways. The reports argue that if it was genuinely redundancy, like RBC said, it should have been handled as a civil matter, focusing on redundancy payments, specific procedures.
Not an industrial dispute.
Exactly. By calling it retrenchment, the EPA pushed it into the industrial court system, which the reports say was just the wrong venue, the wrong process. So the core issue, the redundancy itself, was never properly addressed for these officers through that channel.
Okay, that's a major point. And then there's the issue of the information used in that EPA filing. That sounds quite serious, too.
Oh, definitely. The reports describe how confidential records, personal and employment details sourced from RBC were apparently attached to that affidavit we mentioned.
What kind of details are we talking about?
We're talking names, dates of birth, job roles, termination dates, even bank records for all 42 individuals.
Whoa, that's incredibly sensitive stuff, just attached to a legal filing.
That's the allegation. And it immediately brings up huge data protection red flags, doesn't it? And constitutional rights, too. The reports mention Section 4C of the Constitution, the right to respect for private and family life. Putting all that private data out there, it's a very serious claim.
Yeah, absolutely. And amidst all this, some of the officers themselves tried to get representation, didn't they? For their redundancy benefits specifically.
That's right. A group of 14, according to the reports, they apparently pooled some money, $1,000 each.
Yeah.
And the intention was clear. Pay this money to an industrial relations officer, Harrison Thompson, to pursue a legal claim about unpaid or disputed redundancy benefits. They wanted their redundancies sorted out.
Makes sense. But did that happen? Was a redundancy claim filed for them?
The reports state quite clearly that no such redundancy claim was ever initiated on their behalf.
Oh, so where did the money go? Or rather, who did Harrison Thompson end up representing?
Well, this is where it gets complicated. Court records for ST-006 of 2015, that's the EPA's retrenchment case, show Harrison Thompson appeared as the representative for Party 1.
And Party 1 was?
The Estate Police Association, the union.
Wait, so the officers paid him, thinking he'd represent them individually on redundancy, but he actually represented the union in the retrenchment case.
That's the interpretation put forward in these reports. It suggests Thompson was acting for the union, not those 14 officers directly on their redundancy issue.
That feels very problematic. Misleading, even.
Yeah.
If they paid for one thing and got another, and their core issue still wasn't addressed.
Exactly. The reports argue this just confirms that the EPA was the legal party driving ST-006, and those 14 officers, despite paying, effectively had no representation for their specific redundancy claim within that process.
Okay, so let's try and piece this together. We've got questions about the EPA's right to file in the first place.
Lack of standing, yeah.
The mid-classification of the dispute as retrenchment instead of redundancy.
A critical error, the reports say.
The alleged misuse of very private data.
Big privacy concerns there.
And this issue where officers tried to get representation for redundancy but seemingly didn't.
Right, their funds potentially supporting the union's case instead.
So, if you add all that up, the reports seem to be building a case that the Industrial Courts Tribunal might not have even had the proper legal authority, the jurisdiction, to hear ST-006 of 2015 at all. Is that fair?
That's precisely the conclusion the reports are driving towards.
Yep.
They argue that this chain of alleged failings, the potentially invalid registration, the procedural problems, the wrong classification, the lack of proper representation for the individuals on the redundancy issue, it all combines to undermine the tribunal's jurisdiction over that specific matter.
Wow.
And they even point to verbatim notes from the initial tribunal hearings, apparently, suggesting the actual issue of redundancy was never really the focus of the discussion there.
So if these reports are accurate, if these proceedings were fundamentally flawed, what happens now? What can these affected officers actually do?
Well, the potential legal consequences are pretty substantial. If these claims hold up, ST-006 of 2015 could potentially be declared null and void ab initio, meaning void from the very beginning, as if it never legally happened. That could effectively hit the reset button.
Okay, a reset button.
Yeah.
And what specific actions could they take after hitting reset?
The big one would be reclaiming their right to proper legal representation, to finally bring forward a legitimate redundancy claim against RBC, address the issue that was seemingly bypassed.
Finally get that redundancy issue heard properly.
Yes. They might also be able to seek a formal declaration from the courts that the EPA acted unlawfully or ultra-vires beyond its powers.
Right.
And then, given the allegations about the data misuse and the potential misrepresentation regarding the legal fees and representation, the report suggests constitutional remedies, possibly even criminal ones, could be on the table.
So, multiple potential avenues opening up if ST-006 is deemed invalid.
It seems so. The core argument running through these documents is that ST-006 was never lawfully initiated, lacked a proper legal basis, involved unauthorized data use, and misclassified the workers' situation.
Okay, so wrapping this up, based purely on these reports we've looked at, the picture painted is that the ST-006 of 2015 proceedings are potentially invalid due to a whole host of alleged issues.
Yeah, problems with standing, classification, data, representation, jurisdiction. It's quite a list.
And the significance for the former RBC estate constables is huge. It could mean they finally get a chance to pursue legal action focused squarely on their redundancy and the alleged misconduct surrounding how their case was handled.
Exactly. The potential invalidity could be the key that unlocks the door to addressing what they see as the original unresolved issue.
It really makes you think, doesn't it, about how vital procedural fairness and proper legal representation are. When those things are allegedly compromised, as these reports suggest happened here, well, what are the consequences? It definitely leaves you considering the importance of protecting workers' rights and ensuring everyone has genuine access to justice.
A lot to consider, definitely.
Indeed. Thanks for taking this deep dive with us today.